It's live now.
All right, Trustee House, whenever you're ready.
Okay,
Oh,
so
wait, okay, there's Carrie Lynn. All right, I think we're ready now. Whenever you're ready.
ready? Okay, so we will call together the municipal board for January 4th, 2021. And the first thing is going to be our statement of findings of in-person meetings and unfeasibility due to the COVID-19 pandemic. Attorney Samuelson, can you read that into the record for us, please?
Sure. Please be advised that on December 11th, 2020, the governor of the state of Illinois issued his latest statewide disaster proclamation related to the continuing public health emergency posed by the COVID-19 pandemic, and has further issued executive orders implementing further enhanced mitigation measures and restrictions. As such, pursuant to Section 7E of the Illinois Open Meetings Act and the rules of procedure, as the chair of this board has determined that holding a meeting entirely in person that is otherwise conducted in full compliance with the Illinois Open Meetings Act is neither practical nor prudent because of the ongoing disaster. To the extent necessary, this meeting will be conducted with the option to participate via internet teleconference and without requiring the physical presence of a quorum. The chair further finds that due to the disaster, the physical presence of more than 10 people at the regular meeting location in an accessible, hygienic, and legally compliant manner is not feasible. Alternative arrangements have been made to allow the public to contemporaneously hear all discussion, testimony, and roll call votes via Zoom teleconference. All votes shall be conducted by roll call vote, and a verbatim recording of this meeting shall be made and maintained in accordance with the Open Meetings Act. All participants are hereby further notified that by participating at this meeting, they acknowledge and are informed of this meeting's public recording. Thank you.
Thank you very much. For clarity, we are calling right now, the case is DMOEB-01, Belcher versus Andrew Holmes. Clerk Dugan, if I can ask, would you do a roll call to establish a quorum?
Chair House,
Present.
Member Craftifer.
Oh.
Carrie Lynn. You're on mute.
Okay, present. Sorry about that.
Clerk Dugan present.
Okay, and then we want to get appearances by all parties. So do we have all parties present?
Yes, Tiffany Nelson Jaworski on behalf of the objector.
And the attorney for the candidate has waived his appearance for this meeting.
Thank you very much. And there are no further proceedings to object. So the next thing to move on is signing of the decision of the objections petition. So let's see here. So Attorney Samuelson, am I reading this into record? Just the objector withdrew the petition or withdrew her objection. The electoral board voted to find the candidate's nominations papers to be valid.
Yes.
Now the electoral board must execute and sign this written decision. Because this open proceeding is being held via remote means, each board member will sign and affirm on the record that they are contemporaneously signing. They will then email the board attorney a copy of the signature page. The electoral board's attorney's office will compile all of these into one document. If any of the parties or attorneys appearing on or at the hearing, the executed PDF will be served upon them via email, and we will wait for them to affirm their receipt on the record. If any party is not present, they will be sent a copy.
Oh, Trustee House, you just went on mute somehow.
Oh,
There he is. He's back.
I'm back. Did it go halfway in? Okay. Where did I drop off?
Right there.
If you want to reread paragraph C, and I don't know that instead of waiting for those on the hearing to affirm that they received their copy of the signature page, because I don't know that we'll get all the signature pages back to me in time for them to affirm. I would just say that I will send an email copy, and then the decision will be sent to all parties via certified mail, if that's okay with Mr. Arski.
Agreed.
Okay, sorry about that.
So the next thing is just for our signing. Am I
Yeah.
correct?
For everybody to sign, and then we'll go through and each person will affirm that they signed it contemporaneously.
Okay. Well, I'm Jason House, the chair of the committee. I affirm that this is my signature and I have signed it right now.
Okay.
And Carrie Lynn Craftifer, and I have also signed it.
Mary Kay Dugan just signed it.
Okay.
That should conclude all business to be done on this case. I'll make a motion that we adjourn this case to move on to our next one. I have a second.
Second.
Okay, motion and seconded. Clerk Dugan, can I ask for a roll call, please?
Sure. I'm sorry. I didn't hear who made the motion.
I made the motion.
Okay, thank you. Okay. Chair House,
Yeah, aye.
Member Craftifer,
Aye.
Clerk Dugan, aye.
Okay, 3 ayes. This meeting is adjourned. So next, I guess we move directly into case that we'll call to order. It is case DMOEB-02, Belcher versus Riley H. Rogers. So roll call to establish a quorum for this hearing.
Chairman House,
Present.
Member Craftifer,
Present.
Clerk Dugan present.
Okay, all three are present. Quorum has been established. Any appearances needed for this hearing?
Tiffany Nelson Jaworski on behalf of the objector.
Dennis Giannopoulos on behalf of the candidate.
Okay, having all parties present, there are no further proceedings, so we're going to move right into the signing of the decision of the objector's petition. The objector withdrew her objection. The electoral board voted to find in the candidate's nomination papers to be valid. Now the electoral board must execute and sign its written decision because this is an open proceeding being held via remote means. Each board member will sign and affirm on the record that they are contemporaneously signing. They will then email the board attorneys a copy of the signature page. The electoral board's office will compile all of these into one document, similar to the last hearing. The electoral board, well, our attorney will then send those decisions out via certified mail if that is okay with all attorneys present.
No objection.
That's fine, no objection.
Okay, hearing no objection, I'll ask that all board members sign and affirm the decision. I am Jason House, the chairman of this committee. This is my signature, and it will be emailed over to our board attorney.
Carrie Lynn Craftifer, and this is my signature on the decision.
Mary Kay Dugan, my signature on the decision, just me.
Thank you to everybody. Saying that there should be no further business to conduct on this one, I make a motion that we adjourn.
Second.
Second.
Okay.
It being motioned and seconded, Clerk Dugan, can you do a roll call, please?
Chairman House,
Aye.
Member Craftifer,
Aye.
Clerk Dugan, aye.
3 ayes. This meeting is adjourned. And next, we will go into we're going to call to order case on the docket, Belcher versus Shaw, DMOEB-03. So we're going to move to adopt or reincorporate the statement of finding in-person meetings unfeasible due to the COVID pandemic, as read in the case of 2020 DMOEB. A motion that we adopt that into from the reading from the first case into this hearing.
So moved.
And I'll second. So if I can ask Clerk Dugan, please do a roll call.
Chairman House,
Aye.
Member Craftifer,
Aye.
Clerk Dugan, aye.
Okay. And Clerk Dugan, can we do a roll call, please, quickly to establish quorum?
Chairman House,
Present.
Member Craftifer,
Present.
Clerk Dugan, present.
Okay, a quorum is established. And then any appearance by attorneys on this case?
Tiffany Nelson Jaworski on behalf of the objector.
And Keith Spence on behalf of the candidate.
Okay, all attorneys being present. At this time, I would like to ask if there's any public comment that has been made regarding this case. Attorney Samuelson, any public comment on this case?
I'm waiting for Giovanni to hop on and let us know, but I can check. If you give me just 1 second. I'm gonna briefly go on mute. There's no public comment.
Okay. Hearing no public comment, I'm going to do a recap of the status of the case status and filings. First, there was initial hearing held on December 15th, 2020, and case management was ordered and issued subsequent thereto. The second hearing was held on December 22nd, 2020. A hearing was held on the candidate's motion to strike and dismiss. A case management order was issued subsequent thereto. And third, the candidate filed a list of witnesses and exhibits on December 31st, 2020 at 12:12 p.m. Move into our proceedings on the objector. So we have the objector's verified petition, and I will ask that our objector make their first presentation or argument.
Okay, thank you. First of all, I just wanted to say, thank you to the Electoral Board for their time on this case. We have done our due diligence and tried to investigate some of these matters as it relates to the candidates, what we believe to be the candidate's lack of residency. And at this time, the main thing that we found is that the candidate is still an active voter in the city of Chicago. As such, I do not believe that we will be able to sustain our burden of proof as it relates to the residency objection. And we will go ahead and withdraw we'll just rest on our objector's petition, and the candidate can obviously present whatever documents or evidence they want to present to refute what we've put forward in our objector's petition.
Okay. That's relating to the residency?
Yes, I'm sorry, solely. So yeah, I'm sorry, I should have said that. I wanted to take this sort of piece by piece, if the board doesn't mind, if we could first focus on the residency issue, and then if after that, if we could focus on the issue as it relates to the notary, because one is a legal issue and one is a factual issue. So as it relates to the facts of the residency matter, unfortunately, our efforts did not bear the fruit that we had thought that it would. And so we will just rest upon our objector's petition.
Okay, so we will be withdrawing the residency objection. I would assume Attorney Spence, no disagreement there?
Well, wait, Ms. Nelson Jaworski, are you withdrawing that objection, or are you asking us to make a ruling based on what you presented?
Yeah, just make a ruling based on what I presented. So there's, it's in the record, that's fine. And then we can, if you don't mind, we could then go forward with the notary question. The question of the date on the notary.
Okay. With that, I just want to make sure I'm following protocol. Attorney Samuelson, we would take a vote on the residency. Am I correct?
I think you take a vote on the entire, well, I guess you can do it in parts.
Well, why don't we hold that issue in abeyance until we hear the rest of the case and then make a final ruling, which has several parts at the end. How's that?
That works for me.
And then if counsel for the candidate wants to make an offer of proof related to what he would have presented related to the residency, that's fine also.
That's fine. And just I am having technical difficulties here, so I am signing in now on my computer. If the host could let me in on that.
It should be letting you in. Did that work?
Let's see. Yes.
Okay, so Attorney Spence, all right, perfect. You dropped off of the one device and you're just, oh, can't have two devices in one room as we're all learning.
Right. Yeah.
And can I just ask something procedurally, because I'm sorry, I'm pulling out my file here. I have a motion to strike and dismiss the objector's petition on case 3. So shouldn't we be, am I correct that that's what we have here? Shouldn't we be proceeding on that before we proceed on anything related to the underlying objection?
You guys denied that motion last time based upon the fact that the candidate had presented an affidavit, which created, essentially, I don't want to say created an issue of fact, but more presented evidence.
Oh, okay. Thank you. Sorry, I'm losing my mind with all these different cases. And by the way, the candidate's information that Ms. Samuelson sent me, I'm still getting those weird hieroglyphics, even on the witness list. So I don't know what happened with that.
Wow, I'm not sure either.
The internet demons.
I can resend it to you directly. I don't know if that would.
That's okay. I mean, I can see through the weird little things to see what it says. And it was your witness list. So, I mean, that's fine. All right. I'm sorry. Proceed.
Okay. So with regards to the residency issue, you're looking for an offer of proof or what are we?
Yes.
Procedure? Yeah, I mean, we submitted along with our exhibit, a certified copy of Mr. Shaw's current residency, his registration, which lists his address at 1527 Berg Street in Dolton. He registered in Dolton in December of 2019, and which is more than a year prior to the February 23rd election. He established residency. He intends to reside and remain in the village of Dolton. And we also submitted a copy of his current driver's license, which lists his address as that 1527 Berg Street address. So based on that, we don't think that the objector has met the burden to prove that Mr. Shaw is not a resident of the village of Dolton.
Okay. Then, Ms. Samuelson, do you want us to deliberate on that particular issue now, or just listen to everything else and then come back to that?
I would say listen to everything else and then come back to that.
Okay, that's fine. All right, so then I guess Ms. Nelson Jaworski, then you would proceed with with your other allegations.
Yes. So I'd like to thank the board again for their time today. And the last allegation I think is a pretty simple one, to be quite honest. The candidate, as well as the candidate's running mates, but right now we're just talking about the candidate. The candidate completely failed to date the notary, or to have the notary dated on the nominating petitions.
Attorney Jaworski, I'm sorry, I don't want to interrupt. It looks like Attorney Spence may have dropped off. I want to make sure we still have all.
Oh, yeah, you're right.
Yes, you're right. Okay, I will keep an eye out and see if he shows back up.
Okay, I'll hold.
Yeah.
He's just having connectivity issues or something?
It seems that way. He's twice had to, well, 3 times tried to re-enter the meeting. So we're off to a great start this year. Zoom and technology issues. All right, here he is.
Although I have to say, I'm so thankful for Zoom.
Yeah.
I just really wish I would have known about Zoom about a year ago and bought some stock in it.
Hi, Attorney
Okay.
Spence.
Hi, I'm back on my cell. My computer, for some reason, wants to have demons this afternoon, but I don't know how much of that you all got, because I saw that I did freeze up.
Ms. Jaworski, Attorney Jaworski was about to give argument on the notary issue.
Okay,
So I would just ask that she restart her argument, so that way you're able to hear everything. Okay?
thank you.
All right.
Absolutely, not a problem. So, we did argue some of this in the motion to dismiss phase, so I don't want to belabor it too much because I think that the board is pretty aware of the issues. But just quickly in summary, the nominating petitions of the candidate completely failed to have the notary date the nominating petitions. Under the Illinois Notary Public Act, specifically section 6-103A, a notarial act must be evidenced by a certificate signed and dated by the notary public. The certificate must include identification of the jurisdiction in which the notarial act is performed and the official seal of the office. The most important thing with that little citation there as it relates to this case is the dating. Again, there is no date at all on these nominating petitions as it relates to the circulating affidavit. In our opinion, that completely invalidates the affidavit, thereby invalidating the petitions. And this is not a passing error. This is not an error that occurred on 1 or 2 petitions. This occurred on 100% of the petitions. So in our opinion, there is no substantial compliance because in fact, there was no compliance at all. The act, the Illinois Election Code requires that the circulator swear to swear to the veracity of his statements or her statements and make that swearing in front of a notary and that it be properly notarized. Well, it says in front of somebody that's authorized to give oaths. So because it says that the statement shall be sworn to before some officer authorized to give oaths, and since notaries are one of the groups of people that in fact are authorized to give oaths, when you appear in front of a notary to give that oath, it's pivotal that that oath be done correctly. The Syntuck case, as previously discussed, is somewhat on point and somewhat distinguishable. What is on point with the Syntuck case is the fact that when the court was looking at this, they had specifically stated that one of the things that they looked at to determine whether there was a violation of the election code and whether the petitions should be invalidated or whether the affidavit itself should be invalidated, thereby invalidating the petitions, was the fact that the circulators in that case and the notary in that case had met the statutory requirements of section 6-103. So in that case, the issue was that the notary, instead of putting their name only in one place, they put their name in 2 places. They put their name where the circulator was supposed to put their name, as well as where the notary is supposed to sign. So the notary's or the circulator's signature did appear someplace else, just in a different spot. So what the court found there is that the essential elements are there. We can look to the petition, and this is similar to the Nolan case. And in Nolan, the court found that if it's somewhere in the petitions and we can find it, then we're going to find the petitions to be valid. However, in this case, that information is simply missing. It is not there. It's nowhere. It's not in any other petitions. It is nowhere to be found. And as such, we can't tell when these documents were notarized. And therefore, they do not comply with section 6-103A of the Notary Public Act. And that, based upon our reading of the case law, that should invalidate the Notary Act itself because it does not comply with the mandatory and statutory requirements of section 6-103A. And again, this is not a passing violation. This is in all 43 pages of the petitions. This is a 100% violation. And because of that failure to comply with section 6-103A and in such an egregious manner, it is our opinion that the candidate's petitions should in fact be stricken. The circulators, well, the affidavit itself should be stricken, thereby striking the entire candidate's petitions, invalidating the candidate's petitions, and precluding the candidate from appearing on the ballot. Thank you.
Attorney Spence.
Thank you, Chairman. Again, I as well won't belabor the points that all of the points that we hit on at the time that we had our motion to strike and dismiss presented. But just to say that the provisions of the Electoral Code are designed to protect the integrity of the electoral process. And again, that access to a place on the ballot is a substantial right that should not lightly be denied. The essential act required under the code is the personal appearance of the circulator before a notary. The fact that the date on the notarization is missing does not impugn the integrity of the oath-taking process. The circulator, in this case, Mr. Shaw, appeared before a notary, indicated that he was the individual circulating the petitions, signed the circulator's affidavit, and it was notarized. Section 710 ILCS 5-710 and the analogous section 10-4 do not say the nomination papers should be notarized, but rather say that the circulator must swear an oath in front of a person authorized to administer oaths. The language of section 10 does not prescribe conduct which must be followed by the notary, but is merely a statement regarding the scope of the notary's authority to administer oaths. There are several cases and most boards in the state of Illinois have also indicated that errors on the jurat for the notary is not fatal to the circulator's petitions. I think, and we've made clear previously that there are several case law, including the case that council's previously stated, where errors on notaries are not fatal, as indicated in the case of Brennan v. Coleman. The Illinois Appellate Court has generally excused what they consider clerical errors on notarial jurats, where the affiant is otherwise correctly identified. There have been cases where individual did not even sign the notary jurat, but were found to be valid. So here, where the circulator appeared before the notary, swore an oath that he signed the circulator's petitions, affirmed that it was notarized by the notary and signed by the notary, and simply was not dated, should not, under the case law as presented in the state of, as it stands in the state of Illinois, and as boards throughout the state have indicated, are not fatal to the circulator's petition. Therefore, we're asking that the objector's petitions be overruled.
Okay.
Ms. Nelson Jaworski, do you have anything in reply to that?
I do. The first statement that I wanted to make, I'm trying to find a copy of the petitions as we're speaking, but I do believe, and maybe the electoral board, if they have the petitions handy, could confirm, I do believe that Mr. Shaw was not the only circulator for these petitions. I believe that there are multiple circulators for these petitions.
Correct.
So that's the first thing I wanted to point out and correct. The second thing is that, yes, I can concede that the Illinois Election Code does state, in fact, that the candidates, or I'm sorry, that the circulator has to appear, and I will quote it. I'm sorry, such statement shall be sworn to before some officer authorized to administer oaths in this state. They could have gone to a Secretary of State's office. They could have gone to Deputy County Clerk, possibly the county clerk, judges, various clerks, the courts can take oaths, and certain other persons certified under the Illinois Certified Shorthand Reporters Act of 1984. And that's provided in the Oaths and Affirmations Act. But what the circulators did here was they purposefully availed themselves to the Illinois Notary Public Act. And by availing themselves to the Illinois Notary Public Act, by selecting a notary to perform this act of signing or of affirming that they have appeared before some officer authorized to administer oaths, by availing themselves to the notary, they then have to comply with the provisions of the Illinois Public Notary Act. The cases that the candidate alluded to, or the candidate's counsel alluded to, a lot of those are Chicago board cases. Some are Cook County Board of Elections cases. Those, in fact, are not binding on this board. The cases that are binding on this board, I believe, have been sufficiently cited both by candidates' counsel as well as myself. The case law is not clear as it relates to a missing date. What I found in my research is that, sure, sometimes there's minor defects in a notary. Sure, sometimes if 100 pages of petitions are submitted and 5 of the pages don't have the notary signature, but they all have the stamp, then yeah, that's okay because that's a minor error. Or they all have the signature, but none of them have the stamp. Okay, again, minor error. And I would even be willing to concede that maybe if, 10 of the pages, 10 of the 43 didn't have the date on the notary jurat. Again, minor error. Probably not anything that should rise to the level of ballot removal and rise to the level of complete noncompliance with the Illinois Notary Act. But what we have here is we do have complete noncompliance with the Illinois Notary Public Act. Section 6-103 clearly requires that the notarial act be dated. Again, if this was just something that was passing in a few of the petitions, that would be one thing. But this is 100% of the petitions. And as stated earlier, that does not equate to substantial compliance. That equates to no compliance. And this is a mandatory provision of the election code. You do have to have your documents signed. You have to have somebody appear. They shall be signed to and sworn before some officer authorized to administer oaths. While minor clerical errors will be excused, this goes beyond a minor clerical error. This is, more akin to not signing every single page of the circulator's affidavits. Again, the cases that the candidate cited were cases in which there were minor issues. I have not seen a case, at least not in my research, but I could be wrong. I have not seen a case in my research that shows that where somebody had failed to do it completely throughout the entirety of their petitions, failed to, perform or perfect the notary in some manner or another throughout the entirety of their petitions where that was deemed excusable. There's got to be a point where the law actually has an effect. And the Illinois Notary Act requires these documents to be dated. So thank you very much.
So I think maybe we should just start with that last issue first, if that's okay with the electoral board members.
Sure.
So it does appear on all of the sheets that the notary jurat is missing any date. However, I believe if we look at the case law and if we look at some other electoral board cases, there is a direction we need to go on this. First of all, the candidates cite the case of Brennan versus Coleman, which is a very famous case that I lost before the appellate court 19 years ago, arguing a position similar to what Ms. Nelson is arguing here. And it's not exactly on point because the notary said she was notarizing the signature of the candidate, but the people didn't actually certify, or they didn't sign their the affidavits at the bottom. They wrote their name in the part where the notary was saying sworn to and subscribed to before me. And while that case isn't exactly on point, I think what is on point is the way that the court went through and analyzed that case. And the court, first of all, cited an appellate court case, or no, I'm sorry, an Illinois Supreme Court case where they talked about, what is the purpose for this requirement that we have something notarized to start out with? So they cited the case of Mugavero, Mugavero versus Kenzler, Kenzler, 317 Ill App 3rd, 162. And that said, well, okay, an affidavit's a written declaration under oath sworn to before a person with authority under the law to administer the oaths. And the reason we have that requirement is so that people are subjected to perjury laws if they actually have somehow violated that. And what the court said is that there's a lot of times when notaries screw up things, and that doesn't mean necessarily that invalidates a petition. There aren't really cases that I can find that say that a violation of the Notary Public Act has the consequence of disqualifying people under the Illinois Election Code. Now, Ms. Nelson-Jaworski is correct, though, that if a petition is not in substantial compliance, you have to comply with the mandatory provisions of the election code. And this is a mandatory provision, not a directory provision. But I don't believe substantial compliance means that they did it on 90 of the pages and they forgot it on 2. I think that it can be, if they've complied with enough of the ingredients that are required to be in a candidate's petition, then that can be sufficient here. So I would find that, notwithstanding the fact that the date isn't included in the notary jurat, that the petitions substantially comply, because it is clear from the face of the document that the notary did actually notarize somebody's signature. There's a seal there. There aren't any other allegations in the objector's petition that I can find that make any allegations of fraud. And there are a couple of cases from the Chicago Board of Elections, which, while they aren't binding on this board, they're persuasive, that actually talk about this. There's a case that involves this exact issue called Lenzen, Lenzen versus Orozco, Orozsco, 01 EBALD 04, which is a Chicago Electoral Board case involving an alderman from 2004. That had the exact issue. There wasn't a date in there. And that electoral board held that it wasn't a fatal deficiency, that it was missing that. There are other cases before the Chicago board where people put the wrong dates of notarization, and those weren't held to invalidate positions. That's Cottrell, Cottrell versus Pearson, Pearson, 99 EBALD 157. And Young versus Cook County Officers Electoral Board, which actually went up on a petition for judicial review. So that's 90 CO20, Circuit Court of Cook County, January 24th, 1990. They're all old cases, but I have not been able to find one that has held this to be a fatal deficiency. So with respect to that part of the objection, if we want to talk about that first, I would make a motion that we deny the objector's petition on the notary issue.
I'll second.
Okay, hearing a motion and a second, one comment from me on there. I think, and maybe I have the disbenefit of not being an attorney, because I tend to think with the date missing on everyone, I think that is zero compliance. So I have a different perspective on this one, but I have a motion and second. Any other comment, Clerk Dugan, for yourself?
Yes, we each had the opportunity to address this issue regarding the other candidates that were challenged on this basis. And so I want to thank the attorneys involved for their very, very thorough summations, plural, and also the electoral board attorney, I believe, whose direction under the other cases was similar to what Member Crafter was saying, that it does not arise to the level of being substantially, I'm reversing actually, non-compliant, and more is a ministerial error than a substantive one.
Okay, thank you for that. Just a restatement of the motion, please, so that when we call the roll, I know what.
Motion to deny the objector, or the objection on the notary issue.
Okay, so that is the motion on the floor. Clerk Dugan, can I ask you for a roll call, please?
Sure. Chairman House?
No.
Member Craftifer?
Aye.
Clerk Dugan, aye.
2 ayes, the motion passes. And I think we did also have the other issue of residency. Would we be calling that at this time?
Yes. So on the residency issue, so the objector says she's going to stand on her pleadings and the evidence before the board. Now, there are a couple of cases that say that electoral boards have to take up all the information before them. So she's filed an information, the information. She's also filed a registration information, making it appear that a Robert Shaw engaged in a Chicago vote. However, the issue that I have with this, I think that the name Robert Shaw is a fairly common name. So I don't know that the fact that somebody has voted under that name in Chicago would necessarily mean that it was this particular candidate after he registered to vote at this location in Dolton. So I would make a motion to object to that, or not. So I make a motion also to deny that objection. And I think Ms. Nelson-Jaworski also admitted that she was going to have a tough time bearing her burden of proof on that.
I'll second that motion. So, any comment? I have no comment on this one. Clerk Dugan, any comment?
No.
Okay, hearing no comment, Clerk Dugan, please call a roll.
On the motion to deny the objection as to residency, Chairman House,
Aye.
Member Craftifer,
Aye.
Clerk Dugan, aye.
3 ayes. That motion carries. And I believe that concludes all matters related to this, and we have to then move to find a date, a recess to a date for signing the decision. Am I correct?
Yes, you're correct.
Okay. So I'll take a poll. Any board members or attorneys or any dates that you prefer?
So Ms. Samuelson, how long will it take you to prepare that?
So I would prefer to have until, I would prefer to have until at least Friday, just because I'm looking at my calendar. We have hearings again tomorrow, and then I have a pretty full week. So I do have Friday open, if that works.
Could we maybe do Monday, actually?
So I know our court reporter has a conflict on Monday. I could do Tuesday. Does that work for everybody as well as the court reporter?
As far as I know, that's okay.
Okay.
Yeah, that's fine with me.
And no objection here. I'll be waiving by appearance.
Okay.
I will as well. So, no objection there.
Okay. So I'm free all day on the 12th. That would be, we're already at January 12th on Tuesday. Anybody have a suggestion on time?
10?
10. Okay. Does 10 work for the other members of the board on January 12th?
That works.
That works.
All right. Then I will have a decision.
I'm on a Zoom call meeting. That's all right.
Okay. So
So then I
then,
would make a motion that we recess this board until January 12th at 10?
Second the motion. And Clerk Dugan, please roll call.
Chairman House,
Aye.
Member Craftifer,
Aye.
Clerk Dugan, aye.
Okay, thanks everybody for your time.
thank
Thank
you.
you.
Thanks, everybody. Have